This is
673.
673, hazardous waste, item number 2 on our agenda.
Thank you, Mr. Chair and members. This bill and Senator De Leon's SB 654 which I'll present later, both make essential improvements to the permitting procedures at DTSC to better protect residents living in vulnerable neighborhoods near hazardous waste facilities. SB 673 enacts important reforms to provide accountability, transparency, and oversight measures that will improve the relationship between DTSC and the communities it is mandated to protect. Recent high-profile cases involving permitted facilities such as the Exide Technologies, a battery recycling facility in the city of Vernon in my district, and in Kettleman Hills, a hazardous waste facility in Kings County, have raised significant environmental justice concerns from the community surrounding the facilities and have led to criticism to the department's permitting procedures and responsiveness to the community concerns. A review of the permit procedures undertaken by DTSC found that there has been significant dissatisfaction with the performance of the department, and in particular, a perception that the office is not responsive to the community concerns. That report also recommended that clear and objective permitting criteria should be developed to establish when permits should be revoked or not renewed. This bill establishes an important opportunity for public participation and input into DTSC's actions through the creation of a community oversight committee. I would like to accept the suggestions of the committee staff outlined in page 7 of the analysis as authors' amendments, and I would also like to suggest the name the California Communities Committee as an alternative to the name in the current version of the bill.
So accepted. California Communities Committee, CCC?
CCC.
Okay.
C cubed.
Oh, see.
SB 673 also creates important additional criteria that DTSC must consider when issuing or renewing a permit for hazardous waste facility. Those considerations, including past violations, financial assurances, and proximity to sensitive populations such as schools, childcare facilities, and hospitals, were all prominent concerns from the community around the Exide facility. Members, it is important that the public have faith and confidence in the regulatory agencies that are entrusted to protecting public health. This bill will go a long way in restoring the faith and improving community participation in permitting decisions for hazardous waste sites. I respectfully ask for aye votes.
You have a witness in support?
Yes.
Please go ahead.
Ingrid Boston with the Center on Race, Poverty, and the Environment.
Welcome back.
Thank you. This bill addresses 2 major problems. One is DTSC's permitting program and the lack of objective criteria. What this bill seeks to do is ensure that when DTSC makes permitting decisions that will impact communities directly living next to the site, that it include criteria on past violations, but also, as I discussed before, cumulative impacts, the social and economic vulnerabilities of nearby communities, as well as providing safe buffer zones between sensitive receptors such as schools, childcare, residences from hazardous waste sites.
Wouldn't that also include subjective criteria from the members of the public who are participating? I mean, it includes both of them, right?
Well, there's 2 provisions of the bill. One is the C cubed, which provides policy recommendations for increasing public participation, for increasing communication and building community trust. And then the second part of the bill requires DTSC to develop permitting criteria through a regulatory process.
Okay, proceed.
So with that, the second part of DTS 673, which is the C cubed, addresses the severe erosion of community trust in DTSC and its ability to protect public health. Communities living near hazardous waste sites have firsthand knowledge of the agency's deficiencies in problems in maintaining open lines of communication and in being responsive to the community. And by providing impacted communities with the opportunity to have a seat at the table and to build relationships with DTSC, both communities and DTSC will benefit from the community's knowledge and ability to participate in such a forum. For that reason, I respectfully urge your aye vote. Thank you.
Excellent. Others in support of SB 673? We're in our special order. Please go ahead, Mr. Alio.
Bill Alio for the Environmental Working Group in support. Thank you.
Andrew Grinberg, Clean Water Action and Support.
Strella Servas with the California Environmental Justice Alliance in strong support and on behalf of the 15,000 plus communities that will be impacted by this bill. Thank you.
Purin Shaw with Asian Pacific Environmental Network, strongly in support.
Others? All right, opposition to the establishment of the California Community Committee and others things on SB 673.
Mr. Chair, members, Anthony Sampson with the California Chamber of Commerce. Thanks for the opportunity to speak here today. I just want to note I'm not going to speak on the C-cubed piece, but instead the other pieces. I should start by saying, we very much are mindful that the current program is imperfect and needs improvement, which is why you've just heard this morning that DTSC is in the process of implementing its permit enhancement work plan, which is intended to improve the hazardous waste permitting program by creating more effective, protective, and equitable permitting system. The Senate allocated funds to DTSC to do that, and that process should be allowed to take its course. But even if the permitting enhancement work plan didn't exist, there are several sections of this bill that have some serious flaws. Specifically, Section 3 requires DTSC to promulgate regulations establishing additional criteria that DTSC shall consider to determine whether to issue a new permit or a renewal of an existing permit. One criterion includes the number and type of past violations that will result in a denial. It's important to understand that DTSC already has existing authority to suspend, revoke, or deny an existing permit for repeat violations. That's already existing law. In fact, on the Assembly side, Assemblyman Alejo has introduced AB 1075, which is attempting to provide some more specificity to DTSC when invoking that authority. So to insert it now, an already existing piece of law, into a permitting criterion is just is odd, and it's hard to understand how that would actually work in process. The second issue, the second criterion, is the vulnerability of nearby populations, and vulnerability, according to the bill, is assessed through the use of the CalEnviroScreen tool and other indicators. This is a tool that was designed to identify communities at the greatest risk from environmental contamination and to use that information as a basis for awarding grants. That tool was never contemplated to be used in a permitting process, and quite honestly, it's pretty unclear as to how it could even be feasibly used in making permitting decisions. It should also be noted that the permitting enhancement work plan identifies several measures, as you just heard from the director, to protect vulnerable populations during the permitting process. Specifically, the permitting enhancement work plan notes that DTSC intends to, quote, create an EJ assessment and engagement process to identify environmental concerns early in the permitting process and better involve communities so they can understand and effectively participate in DTSC's decision-making for permit applications, end quote. Finally, Section 4 requires DTSC to develop and implement programmatic reforms to improve protectiveness, timeliness, legal defensibility, and enforceability of DTSC's existing permitting program. That is precisely the mission statement of the permitting enhancement work plan, so it seems duplicative at best. And for that reason, I urge your no vote.
Go ahead, please.
I'm Gene Urban. I represent two clients, Waste Management and Exide. They have had two of the more controversial permit applications in the last several years. Waste Management, the Kettleman Hills facility, Exide, the battery recycling facility. I'm not sure either client is opposed, but we have some pertinent, perhaps, observations about the combined effect of Senator Lara's bill and Senator DeLeon's bill. As you know, there are less than 120 facilities. Some of them are extraordinarily complex. Some of them involve permits, corrective orders, and settlements that are decades old. The people who wrote them are gone. The meaning is not clear. You can literally have two regulators from this same regulatory entity interpreting them differently at times. It's very challenging. I think the quest for a formulaic rule or series of rules on how to permit these facilities is futile. In the past, I have suggested that we create a strike unit or a special designation that will inform everybody, legislators, community activists, interested members of the public, that this facility or this handful of facilities is not going to meet the timelines that are otherwise applicable because of extraordinary circumstances which no one here can anticipate in any given moment. I think it's only fair to know that no regulatory entity could possibly meet the demands that surround some of these facilities, and specifically Kettleman, which the permit application was essentially suspended in the final years of the Schwarzenegger administration, during which time 5 studies were conducted, not by the applicant, but by federal and state regulatory entities, studying birth defects, cancer clusters, air, water, and PCBs. I think I have that right. I'm not quite sure I remember. It was literally suspended while those reports were prepared and then assessed. I strongly urge you, if you take the De Leon bill and the Lara bill, licensing and renewing these facilities will be virtually impossible in the handful of cases that drive the public policy. With regard to Exide, I'm very interested in the Wykowski corollary, which is if we generate it, we need to handle it. It's not clear to me that's going to be the result of the Exide denial of the permit. Those batteries, some will be handled in the other facility in California. Some will go to other states. I'm very confident, I don't know this, but I'm quite confident some will go out of the country, where we all know to an absolute moral certainty they will not be handled pursuant to the same regulatory regime, because the South Coast's rules and the DTSC permit is the toughest, most protective regulatory regime in the world. And that facility will not be operating pursuant to that regime now. Lastly, I want to make one more point, which I've made before, Mr. Wykowski, and I apologize, but much of the waste deposited at the Kettleman Hills facility is not hazardous waste when it gets to the borders. Perhaps 80 to 90% is non-RCRA. It's not waste when it gets to Oregon, Arizona, Nevada, and elsewhere. It is solid waste or garbage. It can be deposited in facilities that are not highly engineered, do not have double leachate collections, do not have DTSC personnel on site a lot, if not constantly, a lot. That's something that we've never wrestled with as a state. We eagerly label stuff hazardous here in California, but we are very reluctant to treat it in communities, and we're really reluctant to dispose of it in California. It's a conundrum. All I can tell you is that if you make these bills, I believe, will make it almost impossible for some of these facilities to have their permits renewed, and you will be in violation of the Wykowski corollary. We will not be handling in an appropriate manner that which we label hazardous and that which we generate. Thanks.
Others opposed to 673, please come forward. All right. Can't really deny it.
Thank you, Chair. Tom Jacob on behalf of the Chemical Industry Council of California. We view resolution of these permit issues as critical to maintaining a fully functioning economic structure in the California Republic. We also believe that share the concerns outlined by the prior 2 speakers, that we have very serious reservations about this particular proposal and the 2 that are on the agenda today, and therefore oppose them at this time. Thank you.
Thank you.
Mike Rogie with California Manufacturers and Technology Association. We're also opposed. I'd like to just reiterate Gene's qualms that we really believe California should be dealing with its own waste, not more or less pushing it outside the state. Thank you.
Chris Maurer on behalf of Clean Harbors. We also oppose for the reasons already stated.
Mr. Chairman, members, Jeff Sickinger with KP Public Affairs on behalf of Western States Petroleum Association. We're particularly concerned about the implications of this bill and SB 654 on facilities that are in the process of cleaning and closing former RCRA units. We think the bill, much as Mr. Urban indicated, establishes hurdles that will effectively have negative impacts on the communities around the facilities.
Okay, others? All right, let's bring it back to the committee. Members, do we have specific questions of the author on SB 673? Senator Bates.
Thank you, Chairman Wieckowski. I'm new to the issue in terms of state regulation, and I certainly want to say that I am, totally in support of the direction you're trying to go in terms of protecting public safety. But what strikes me as I listen to the debate is that these companies are our partners actually here with the state to deal with toxic waste. The timelines that are provided in this bill, to me, are almost impossible to meet when you hear the complexities that the companies have in developing the permit. We heard about the agency itself and the complexities that are there in issuing the permits. We haven't given a lot of stock to the companies that have to actually prepare these. So I'm concerned about the timeline. Additionally, we've built in a public review process with this committee, and there's no discussion on how that would affect the timeline. I would be much more comfortable in trying to develop something that really secures public safety, and certainly for our communities that have to live by these. There's no question that they're impacted. But to set up a system that can't do the job and can't get us there seems to be counterproductive to what we're trying to accomplish. And I think we need to look very, very carefully at this timeline. If you have a legitimate one that the partners in this venture can on both sides meet, then I think we're closer. But this clearly disadvantages, I believe, the companies that are our partners to get us where we want to go. And if they can't meet it, do they keep operating and get sanctioned and penalized, or do they go out of business? And then who does it? Does the state have to take over the whole operation? And that's what kind of comes through when you hear the concerns with what is being required. Basically on both sides of the issue, with DTSC trying to develop and address the permit process and those who apply for their permits, what the timeline is doing to them, and then they're punished if they're not issued the permit, which could be the state's fault. So if you'd help me understand how all that works would be more helpful, and at least getting me to understand, not necessarily supporting it until I think that there's more opportunities for both sides to do the job we want them to be doing.
Mr. Chair, if I may have my witness respond to Senator Bates' question.
I just want to be very clear in terms of what this bill does. What this bill does is it asks DTSC to adopt permitting criteria. DTSC is already embarking on internal policies. And so what this bill does is require it to be done through rulemaking, have public participation, and also to have the legislature guide some of its what the criteria should be. So I think there's some conflation with the two bills, as well as I don't think there was any clarity in terms of the remarks made earlier about why having permitting criteria, which DTSC has already said it wants to do, would somehow close all the businesses in California. There's been no nexus explained to me that I understood, and because DTSC is already engaged in this, and because nobody's expressed any opposition to the public body that will help guide DTSC's efforts moving forward, I think the concerns have been overstated greatly.
I think this specific bill, 673, although there's lots of things I can talk about the permitting process in general, this is asking DTSC to improve protectiveness, timeliness, legal defensibility, and enforceability of department's permitting process. So this is a statutory fix on some of the things that the enhanced work plan is doing. Plus, we've got an advisory committee of CQ or whatever we're calling it.
And Mr. Chair, if I can, again, I mean, I can take this as my close as well. You know, the existing law is very discretionary for DTSC itself, doesn't know when it's appropriate to deny based on past violations because there's no criteria. And we know they're working on that. We're going to continue to work with the department to help streamline as the measure moves forward. And, you know, the opposition was talking about the people in the department who wrote this criteria may be gone, but the people that are living and are affected by these companies still remain. Cancer clusters are a reality. Asthma clusters are a reality in my community and in Senator De Leon's district and throughout the state where we have these facilities. That is why we need these bills to protect the communities. And the responsibility, I get the responsibility, and I agree with you 100% that we need to clean up the hazardous waste that is created in California. But also, what about the responsibility for the communities and for our constituents that are affected by these communities? They equally deserve the same responsibility from the legislature to ensure that they are able to lead healthy lives. And to shut down these facilities, quite frankly, have been operating with interim permits for over 30 years. That is not necessarily the company's faults. That's DTSC's faults in their system, which we hope through our current discussion and through these reforms, we're going to continue to be able to capture these companies that are operating under interim permits that shouldn't have. And, you know, the responsibility also falls on us to take care of our constituents of our state.
We have a motion, Senator Leno? We do have a motion. Thank you. The motion is to pass this. Oh, we don't have. We can't entertain a motion because we're a subcommittee. Excuse me.
I wasn't going to say anything.
False thing. I'll take that as your close. Thank you very much.
Thank you.
Let's move our attention to item number 1, SB 654 regarding permitting. This is item number 1 on our agenda.
Thank you, Mr. Chair, members. I'm presenting this bill on behalf of Senate President Pro Tem De Leon this morning, as he isn't able to attend the hearing, as you previously mentioned. My statement, again, my previous statement about the faith and confidence of the Department of Toxic Substance Control and its management of hazardous waste is crucial to the success of the program. However, as illustrated in my and Senator De Leon's district, the department has failed to adequately protect those communities most affected by hazardous waste facilities. And there is no confidence in the department to ensure that these facilities are operating with current and protective permits. Senator De Leon's SB 654 works in concert with my bill to reform DTSC's permitting program. This bill aims at ending an ongoing continued of expired permits that has created a backlog that we must, that you just heard DTSC talk about. SB 654-1 requires hazardous waste facilities permit applications to submit a complete Part A and Part B application at least 24 months prior to a permit expiration. And 2, requires DTSC to complete its review of a permit application no longer than 36 months after the permit expiration or the facility can no longer operate. This is a simple bill that puts logical, reasonable limits on a process that to date can go on in perpetuity, as we've seen. The Excite permit, for example, members, and for our Senator Bates, who wasn't here last year, the Excite permit was an interim status for over 30 years. There are many facility permits that are expired, and that the facility continues to operate without any penalties, while DTSC goes on without a deadline for completing its review process. Members, could you imagine your license expiring and being allowed to go on for a decade or 2 without a current license? And during that time, you receive tickets for moving violations after moving violation, and no one takes your license away or even makes sure that you do what you need to do to renew your license. How is it that a facility that has the potential to create so much harm to public health and the environment is allowed to continue to operate without any repercussions when a permit expires? Members, I ask for your aye vote when you are formally have a quorum.
First witness in support.
Again, Ingrid with Center on Race, Poverty, and the Environment. Oh, I'm sorry. We are in support of this bill, and I just want to preface my remarks by recognizing the purpose of the legislature's passing of a statute that requires regular 10-year permit renewal processes. And the reason why the legislature determined that was so important is recognizing the very dangerous nature of these facilities, and recognizing that by having regular turnover, regular permit renewals, it's a way to hold operators accountable by having to go through the process again. It's an opportunity for DTSC to consider compliance history. It's an opportunity to consider financial assurances, and it's a mechanism to ensure that hazardous waste facilities are using the appropriate and up-to-date technologies that continue to get updated throughout time. And so this is not a victimless problem. When facilities are allowed to operate on expired permits for decades at a time, there is no accountability. There is no assurances that the best technologies are being used. So we do think this is a serious problem. And so when looking at this bill, it's important to view the appropriate balance between the rights of industry and the rights of communities. And for far too long in DTSC and hazardous waste management in California, that the balance has been tilted very heavily in the favor of industry. And we've seen that coming to light these past few years, where communities are suffering immensely, like around Exide, like around Fibrotech. And so what this bill does is it creates a reasonable time frame upon which DTSC must comply with the law. It's already the law that 10 years is the time period for permit renewal, and puts a reasonable time on allowing a facility to operate on expired permits. So we think this is a reasonable approach. It's a good balance between industry and community rights, and we support the bill. Thank you.
Before we hear from the others in support, I have a couple of problems with the bill as it's currently drafted. Currently, right now, the law is you have 6 minutes to submit your application. If this becomes law on January 1, there will be 100 facilities that will have not submitted their applications 2 years in advance because the effective date is January 1st. So they are complying with the law. If their permit is due July or August of next year, they don't have to submit it right now under current law for renewal till February. So if we're saying if this became law, you'd be out of compliance. And there's enough things that are wrong, but I'd like to have some attention done to the effective date. The second, I guess, is the second concern that I have is the 36-month. We just had an oversight hearing. In the bad old days, when we had 95 people at DTSC, it took 3.6 years. Now we have 24 people there, and we're tightening up things. We're making them to do the whole review, and we've only given them temporary help to work on the backlog. We haven't given them any temporary help to work on the new application. We're just saying we funded it. So the question is how are they going to meet that goal if we don't fund the positions to do it? So that's
Mr. Chair, can I have Kip Lipper from the Pro Tem's office answer your question?
please.
Thank you.
Thank you, Mr. Chairman. Kip Lipper with Senator De Leon's office. With respect to your first point on the operative date, I think that the Senate Pro Tem would like to work with you on that and to make it a workable date. I don't know that we're locked into that particular approach, but we do want to hold these facilities accountable. With respect to your second point, it's a very good one. It's a budgetary point. It's one that relates to the permanence of the positions, as you mentioned earlier, as well as to increasing the positions. And I think Senator De Leon would work with Senator Wolk, Senator Pavley, the members of Budget Subcommittee number 2 to address those concerns with respect to both the permanence and the number of positions that are available for this purpose. The objective isn't to impose an unreachable or unattainable goal. The objective is simply to make sure that facilities have the most basic permit in place before they are allowed to operate, and to cause some of the issues that have arisen with respect to Exide and other facilities.
Yeah, it just, I mean, I know it's one thing to set these goals, but it's another. We never fund it. We only fund it to catch up on the backlog, not going forward, keeping a time frame that we've never met. But let's hear from
Senator. I just want to make one other point, and again, with all respect to the executive branch, the funding of these positions is determined by the governor and the Department of Finance. The legislature can augment those positions, but we have had in the past instances where administrations have either reduced those positions to temporary or eliminated them, blue penciled them, in part because of the lack of funding sources at DTSC to pay for some of these positions. So I do want to say it's a shared responsibility between the two branches of government.
I'm mindful of the fact that people are paying fees in order to have their permits and to operate their facilities, and that's yet the topic of another oversight hearing that we'll have going on. Supporters of SB 654, please come forward.
Bill Alio for the Environmental Working Group. We're catching up to the amendments, so I guess I'll give the infamous support in concept at this point. Thank you.
Others? Opposition to SB 654.
Mr. Chair, members, Anthony Sampson, California Chamber of Commerce, in opposition to 654 as well. I want to make sure we're all very clear as to what this bill does, because it's very simple. What it says is that if DTSC does not act within the specified timeframes in this bill, then the project applicant will be deemed in violation of the law, notwithstanding the fact that the project applicant may have acted diligently and in good faith throughout the entirety of the process. The due process violations associated with this bill are absolutely astounding. No notice, no opportunity to be heard with respect to a sudden violation simply because a permitting agency did not act within a specified time frame. By way of comparison, if you look at the Permitting Streamlining Act, which governs local permits, the lead agency is required to take final action on a permit within 180 days from the certification of an EIR or 60 days from the issuance of an ND or a categorical or an exemption. And if they don't act within that time frame, then the permit is deemed automatically granted. Now, the government code is also very specific that hazardous waste permits, that provision doesn't apply to hazardous waste permits. But what it does say is that if DTSC does not act within those specified timeframes, then the permit applicant can seek relief by way of the Code of Civil Procedures, Section 1085, to seek a writ. In other words, if DTSC doesn't act within the specified timeframes of the Permit Streamlining Act, then they can actually seek relief. But this bill says, no, you can't seek relief without being in violation of the law first. That is just bad public policy, and it's blatantly unconstitutional. For that reason, we oppose. Thank you.
Thank you. Others in opposition to SB 654?
Gene Urban, I'm sorry. Just a few brief remarks. If I confused the committee previously, I apologize. I was conflating the two bills. I specifically said.
No, you did.
Okay, thank you. I don't think we should consider these in isolation. Just a few brief remarks. These permits, these facilities are not static. And as the director said in the oversight hearing, there are numerous co-regulators. The Exide facility was not operating and had not been operating for about a year when DTSC informed Exide that its permit would be denied, and I think the permit was withdrawn. I'm not quite sure, but it's been abandoned. It wasn't operating because it couldn't meet South Coast Air Quality Management District air emission rules. It was installing equipment to permit it to meet those air emission rules. So there's air, there's water discharge, there's all sorts of regulators. These facilities are not static. So the fact that a permit has expired, issued by DTSC, does not mean the facility is unregulated, does not mean it isn't subject to numerous other regulatory regimes. Lastly, there's a lot of discussion and a lot of legislation about multiple violations. I get that. But if Senator DeLeon's bill is computed on a daily basis, that for every day the application doesn't issue, you are in violation, you will amass multiple violations very rapidly, and that becomes a basis to deny the permit. So there's an unfairness there. If it's computed, am I stretching, Mr. Lipper?
Yes, you
Well, I'm sorry. I'm sorry. That's the only observation. If it's computed as multiple violations, we have a concern. Thank you.
Understood. Thank you.
Tom Jacob, Chemical Industry Council of California. Just to reiterate the point earlier, there's a lot at stake here. The functioning of the California economy depends upon the effectiveness of these laws. We have a real challenge. We respect the motivations behind both of these bills, but for the reasons expressed, we have fundamental concerns that we may be compromising our end goals and have very serious concerns about them at this point. Thank you.
Mike Rogie with California Manufacturers and Technology Association, in opposition for the reasons previously stated. Thank you.
Chris Mauer, on behalf of Clean Harbors, we're also in opposition for the reasons already stated.
Thank you.
Jason Schmelzer on behalf of the Western Placer Waste Management Authority for the reasons stated. Thank you.
Jeff Sickinger on behalf of Western States Petroleum Association in opposition.
Thank you. Others in opposition? Senator Laura, I'll let you close now. I'm trying to grapple with what does it mean when a permit expires. You know, we've operated in a state that tries to do the best to process their hazardous waste, to identify materials that, as opposition has said, is not hazardous waste, and try to be the beacon in the world of cleaning up, identifying, and making this a wonderful place. And with that said, we only allow facilities to operate for 10 years. I mean, when you get into this field, you know that you operate for 10 years, but they provide a function for us. That this is an ill effect of our current society that we produce these wastes. So we do have a permit that expires. So we're trying to tighten up those timelines. And I'm mindful of what the opposition has said here. I'd like to hear your close and any questions. If you, Senator Leno, if you'd like to have a question.
Just one question. If in your close you could address the issue of due process that was raised by the opposition.
Perfect. This is not my bill. I'm gonna have Kip. I'm gonna have Kip attempt to answer the chair's question and Senator Leno's question, and then I'll just bring it all together with glitter and pizzazz.
Mr. Chairman, firstly, I want to reiterate again the desire of the pro tem to work with the committee and with you on the timeframes so that we are not essentially putting people in a catch-22 where they're deemed to be in violation and there are multiple violations that stack up, as one of the witnesses said, and where the department can, I might say under current law, they have the discretion, but they can impose penalties. So first of all, we'd like to work with you on that as the bill goes forward. Secondly, with respect to Senator Leno's question, I would say two things. One is the way that this bill is intended to work is on a very simple premise, which is these facilities, which are handling very dangerous wastes, ought to have a real permit to operate, just as, I might say, garbage facilities and a variety of other high-polluting facilities from air, water, and waste do. The only rule that Senator De Leon is looking for here is to make sure that these facilities have a valid permit and don't operate as Exide and others have, not for days or months or even years, but for decades without valid permits. Working out the details of how that operates, Senator, is I think the pro tem is interested in, and we would work with you. I honestly don't think, I think the dramatic statement of one of the witnesses about the deprivation of due process is wrong. In fact, the department, under law, has public hearings. They have kind of an odd process where they actually issue the proposed decision on a permit and then hear from the public after that, but there is a public process for the issuance of these permits. So I think that statement, while dramatic, is mistaken on the law. And lastly, Mr. Chairman, I think Senator De Leon would say there is a lot of discussion here from the opposition about the rights and remedies of the industries that operate these facilities, and that is a valid discussion. But there's been very little discussion about the rights and remedies of the communities that live around these facilities that have objectively and by the admission of the operators of these facilities lived with lead pollution and other pollution that is toxic. So the question here is, there's a balance that's needed, but at a very fundamental level, having a permit, a valid permit for these facilities to operate, and having a time frame so that they can get that permit is a fundamental position of the pro tems in terms of moving forward. But I do want to emphasize again, the issues that have been raised, we want to work with you, and I think the pro tem wants to work with you on the timing of the permit, and certainly not put people in an untenable position where either they're being affected on their due process rights or where they're being put in violation of the law simply by virtue of the fact that the department did not act appropriately.
Okay, that's our close.
Mr. Chair, if I could, I just wanted to say, and I appreciate Mr. Lipper's comments because I was struggling with that same issue of due process and certainly the 36 months or the facility is deemed in violation, which to me is DTSC, as we know, has been a failed organization, failed department for years, and because of that, then to put the facility, who in many cases hasn't acted as the angel in the community, but to put them at risk for this, I think, is unfortunate. So I appreciate that you're going to craft something that'll work here. So thank you.
Thank you. We're concluding our special session.
Did you want a motion on the bill?
We don't have a quorum.
Oh, we don't have a
We haven't established a quorum. So the chair notes that there are no senators in the committee room. Therefore, we will turn our attention to item number 26, SB 718 by Senator Leno regarding hazardous materials response and restoration.
I can do that. And then also, I've got another bill.
29.